First and foremost, I'd like to apologize to the courts for appearing before them today. I'd like to apologize to the victim in this case. I'm not going to use alcohol or drugs as an excuse for anything. However, alcohol was a main factor in this case. But I take full responsibility for my actions because I chose to make the irresponsible decision consuming too much alcohol than I could handle, causing poor, regretful choices leading to my incarceration. I've read the police reports and feel ashamed, embarrassed, and hurt because that's not the person I am. And I wouldn't be standing here today if I would have just been more responsible. I have 4 younger children that I've let down because of being locked away from them, missing out on watching them grow, having to deal with that as a heartache alone. The only thing I can do now is work on myself while incarcerated, take advantage of all programs they offer, and become a better man and a better father, and not give up doing so. I have to make this my last time in jail, and I plan to. I'm sincerely remorseful to my victim in this case, letting her down when I was supposed to be a father figure in her life. I beat myself up over this every day. Over this, wishing I could take it all back. I just hope she can grow up in life and leave this in the past, and that it doesn't affect her future. Again, I'm sorry to everyone I caused pain to in this case.
What you're about to see is not just a bad decision, not just a lapse in judgment, but a pattern of behavior that shows exactly why some people should never be trusted around vulnerable victims in the first place. The first defendant in today's video tries to do what we see all the time in court: dress his actions up as a mistake, blame alcohol, cry remorse, and hope the judge buys the performance. But Judge O'Donnell is not the kind of judge who gets fooled by emotional speeches or selective accountability. He listens closely, he remembers patterns, and most importantly, he protects the public. And just when you think this hearing can't get more uncomfortable, it absolutely does, especially when the defendant's own words start contradicting each other. Then, as if one disturbing case wasn't enough, we pivot to a second hearing involving a doctor who thought borrowing money meant spending it however he pleased. 2 very different defendants, 2 very different crimes, but both end with consequences they clearly weren't prepared for. Stick around because both endings are as satisfying as they are revealing.
Thank you. Why did you call her after you were in jail?
Because I was told by the detective I was allowed to.
Okay.
I didn't call her, I called my wife and she answered the phone.
All right. And what contact did you have with her about retracting her statement or modifying her statement?
It wasn't retracting. We talked about counseling, going to counseling and stuff, because that was something that they was talking about making them do, and something she said she didn't want to do.
Well, trying to, whether directly contacting her or contacting her through your wife, was wholly inappropriate. And it was further evidence of you trying to take advantage of her at that young age, like you did when this happened.
Now, she asked the detective if she could have contact with me when this case was all started. Then when I went to my preliminary hearing on February 11th, I asked the detective and he told me the same thing.
All right. Well, you're experienced enough in the system to have the wisdom that you shouldn't have been contacting her. Okay. In talking to her, having about anything having to do with this case. So, you've in your statement you say you apologize to her, but then in the pre-sentence report you talk about how you don't believe you did everything you're accused of doing and wanted to take this to trial. What's that all about?
I don't remember exactly what I said, Your Honor, but what I was saying was I don't have recollection of what happened the night of. So I wasn't admitting to, I don't know what happened.
This is where courtroom apologies often fall apart if you're actually paying attention. On the surface, this sounds like remorse. He's saying all the right words. But notice how much time is spent setting up alcohol as the main factor, almost like it's a co-defendant in the case. That's not accountability, that's deflection dressed up as reflection. Judges hear apologies every single day, and what they're trained to listen for isn't emotion, it's ownership. Real responsibility doesn't come with qualifiers. It doesn't come with explanations that quietly shift blame. And when he talks about being ashamed because, that's not the person I am, Judge O'Donnell already knows the truth. The person you are is defined by what you did, not what you wish you'd done differently afterward. Courts don't sentence potential, they sentence actions. And the emotional weight here isn't about how bad he feels. It's about the permanent damage done to someone who didn't have a choice in any of this.
So did you or didn't you do this stuff?
Yes.
And I got to tell you, it doesn't get much worse than this kind of stuff.
I understand.
And I would note in the record that in 2009 or 2010, you were sentenced to prison on a burglary, released on judicial release, and then returned to prison after a violation of the judicial release. And you were released January 7th of 13. You went back to prison on another case on May 1st of 13 and got out in August. Went to prison on an attempted burglary, trespass in a habitation, breaking and entering, June 23 of 16 through August 5 of 18. A whole bunch of theft offenses between that last prison sentence and where you are today. So you've had a lifetime of criminal activity, but none worse than what has occurred here. So I've reviewed the pre-sentence report and a victim impact statement. I've considered what you have said, what counsel has said. And I've also considered that they've made a joint recommendation of 96 months in prison. And so on count, and I've considered all the provisions in 29, 29, 11, 29, 29, 12, 13, and 14. In consideration of all that, on count 5, I'm going to sentence you to a term of 60 months. On count 6, I'm going to sentence you to a term of 60 months that will be consecutive to one another, with credit for 143 days. And consecutive sentences are necessary to protect the public from future crime by you and for appropriate punishment.
All right, get out, man. Come on, man.
Sit
What
down.
you mean, man?
Stay down.
No, man. Get me the fuck out of here, man.
Judge.
No,
And-
you took my plea back, man. Get me the fuck out of here, man. Get me out of here. Get me out of here, man. Get me out of here, man.
Almost done, Judge.
Get me the fuck out of here.
And they
No, man. Get me out of here. Get
consecutive.
me out of here, man. What the fuck you mean, nigga? Get me the fuck out of here. Man, get me the fuck out of here, man.
Let me get my leg.
Get me out of here, man.
Just take him into the chair.
Okay, we're in this chair.
All right.
Let's see you tomorrow.
Show me on your visiting letter
Alright.
for jail and
All
for.
right, man. Stop touching me, man. I'm not doing shit, man. I'm not doing shit. I'm not doing shit.
This is the part of the case that absolutely destroys any sympathy the defendant might have hoped for. When you hear that the crime happened in front of his own children, that alone changes the entire gravity of the situation. Then you add in the fact that he blamed the victim, encouraged her to beg for leniency, and denied wrongdoing during his pretrial interview, and suddenly the apology we just heard feels completely hollow. Prosecutors don't ask for lengthy prison sentences casually, especially in cases involving sensitive victims. Every detail they laid out is meant to show a pattern of manipulation, not just a single incident. And when a defendant claims remorse publicly but privately insists they did nothing wrong and wanted a trial, judges notice that contradiction immediately. This is no longer about rehabilitation, it's about protecting the public. At this point, The only real question is whether Judge O'Donnell will accept the joint recommendation or decide the conduct deserves even more weight.
Let's see, how about, Mr. Hetherington, looks like you're back there. Actually, I've got maybe another file, Pamela Ronaldo Dicus versus Kirk Gold.
That's correct, Judge.
Do I have, Kirk Gold?
Yes,
Anybody?
Your Honor, Kirk Gold is here.
Okay, on that phone, it looks like. Mr. Hetherington, looks like I scheduled this for evidentiary hearing for, I guess, the amounts, it looks like.
Correct, Judge.
Mr. Hetherington, I guess, have the parties talked at all before we proceed?
Yes, for about 2 years, Judge.
Oh, okay. We're kind of at the end of that. Okay. Mr. Gold, are you ready to proceed?
I'm waiting for my attorney to call me back. I put a call into him because Mr. Hetherington proposed a resolution, and I just need to run it by my attorney to make sure it's the right thing for me to do at this point in time. And it was unfortunate the witching hour yesterday, and I understand and respect this court's time, but I didn't get a response. I expect I'll get a response this morning when the attorney gets into the office.
Mr. Hetherington, I guess I'll leave it up to you if it's easier just to see if it.
Your Honor, the issue in this case is this has been ongoing for 2 years. We were here 2 weeks ago. He did not bother to call me until Friday morning. I was out of the office. I returned his call yesterday. We did not have an opportunity to fully discuss the matter until yesterday afternoon. He's had a couple weeks to talk to a lawyer to see what the best outcome would be. We are prepared to move forward.
Your Honor, sir, sorry for the interruption. Mr. Hetherington, I did call you the day after our trial. We did speak on the phone, and I told you that I was going to be working on it and seeking legal counsel. And then, yes, I did try to call you on Friday before the weekend, and you were not available.
Now, it is time set for a motion. Who's your attorney?
My attorney is Maury Lefkowitz.
The only thing I guess, Mr. Hetherington, I'd allow him to do if he wants to make a quick call, I'll let him do that. If it was the proposed, I guess the proposed offer something.
This exchange right here is devastating for the defense. The judge isn't raising his voice, he isn't being dramatic, but he's dismantling the defendant's credibility piece by piece. Contacting the victim after being jailed, whether directly or indirectly through a spouse, shows a complete lack of boundaries and respect for the seriousness of the situation. Judges view this as continued manipulation, not confusion. When Judge O'Donnell points out that this behavior mirrors the original offense, taking advantage of someone young and vulnerable, it's a legal and moral gut punch. And the defendant trying to hide behind what a detective allegedly said just makes it worse. Courts expect defendants with prior system experience to know better, and Judge O'Donnell makes it crystal clear that ignorance isn't believable here. This is where the apology officially collapses under scrutiny.
Pamela Ronaldo Dicus versus Kirk Gold.
Ready, Your Honor.
Okay. You come back here. Do we, oh, there he is.
248 number, Judge.
Yeah, thank you. I just found him. Yeah, he's coming back in.
Hello?
Hi, Mr. Gold. You're back?
Yes, sir.
All right.
Yeah, well, I was actually calling Mr. Rick because I hadn't heard from you for 20 minutes. My attorney's in consultation right now, but he's going to try and call me at 11 when he's finished with his first consultation.
Mr. Hetherington, I'm going to leave it up to you.
I'm trying to get this resolved. I really am.
Your Honor, it's been, like I said, it's been 2 years, and it's been 2 weeks since we were here last, and he didn't call an attorney till last night. We're ready to proceed.
All right. I think at this point we need to proceed then.
Can I have one more chance to at least talk to my attorney and just get an answer for you, Mr. Rick?
I don't agree.
Can I at least do that out of good faith? I know you're trying to get this thing done, and I can appreciate that, but that's just a huge amount. It's a huge amount. If I can get this done and do what we talked about yesterday, then everybody wins.
Well, I thought that's what we were doing right now. I mean,
Well, we are. I just have to run it by my attorney first and make sure that that's the right thing for me to do. I mean, that's what counsel's for.
well, it is, but you're putting your counsel in a bad spot too. He or she should have been called much earlier too. That's the problem.
We had talked, but just we have not connected since.
Mr. Hetherington, I guess if you want to just proceed, we can do it. Or the practical side, if it's a reasonable offer and it looks like it's going to be done.
Your Honor, again, we're ready to proceed. There's been too much delay in this case as it is.
Okay. All right. Let's just proceed with this time then. It is
Please.
just set for evidentiary hearing with regard to the conversions fraud. Do you have a witness, Mr. Hetherington?
Your Honor, I'll just call Mr. Gold.
Oh, okay. Mr. Gold, can you get on video for me?
I'm in the car driving right
This moment is why so many people respect Judge O'Donnell. No theatrics. No unnecessary speech. Just one direct question that cuts through every excuse. Did you do it or not? And when the defendant finally admits it, the tone of the entire courtroom shifts. That hesitation beforehand, the "I don't remember," the confusion, the distancing, all of it evaporates instantly. Judges aren't impressed by half-truths, especially when they involve crimes of this magnitude. And when Judge O'Donnell says it doesn't get much worse than this, that's not hyperbole, that's a judge acknowledging the severity of the harm. This is the turning point where accountability stops being optional. From here on out, sentencing isn't about mercy, it's about consequence.
Well, you can't be driving anyways. You got to pull over for me. Are you pulled over?
I'm pulling over as we speak.
Okay.
Now, how do I do this? I'm on the phone right now.
Okay, you just got to, there's a button that, well, probably at the bottom, it looks like it says video, or it's got a little camera, it looks like. It's got a,
I just have a call screen. That's all I have on here.
Your Honor, I think he's actually on the telephone, not on the Zoom.
oh, you know what, we can
Called
proceed.
in.
Mr. Gold, why don't you raise your right hand for me? You're pulled over though, right?
Yes, sir.
Okay, why don't you raise your right hand for me? You
So,
got your hand?
this is
Hold on. You
this
got
is a
your hand
done deal,
raised?
then, right?
Well, I haven't heard anything yet.
Yes, sir.
Okay, you got your hand raised?
Yes, sir.
Do you swear from the testimony you're about to give will be the truth?
Yes.
Okay. Mr. Hetherington?
Thank you, Judge. Mr. Gold, where are you employed?
I'm in private practice.
What kind of private practice?
Podiatry practice.
So your title is a doctor, is that correct?
Yes, sir.
And back in 2023, is it true that you entered into an agreement with the plaintiff in this case to borrow the sum of $12,000?
Yes, it is.
And did she in fact give you the $12,000?
Yes, sir. She did.
And was the agreement that you would repay that amount within 6 months?
I don't remember the specifics exactly, so I can't attest to that under oath.
Do you recall making any payments on that loan?
Yes, I did make one payment or
And
two
was that
payments.
for-
I'm not sure.
And was that for $1,000?
Yes, sir.
And so you would agree that you still owe $11,000 on that loan, correct?
Yes, sir.
And that occurred, that loan actually occurred back in May of 2023. Is that true?
Yes. I think it was
And-
May. I'm not sure exactly what the date was.
Okay. And then you used that money for some interest personal to yourself. Is that correct?
Correct.
And since that loan and since that initial payment, you've had discussions with the plaintiff in this case?
Yes.
about repaying that loan?
Yes,
And you've not made any additional payments, is that correct?
that is correct.
And then in
I just-
January of this year, did you receive demand letters from me?
I received a letter, I believe it was in the early part of February.
Okay. And then we had some discussions, correct?
Yes,
And I provided you with opportunities to try to solve this matter. Is that correct?
yes, you did. And as I stated to you then, and I'm saying to you now, it was a cash flow with insurance issue, and I was trying to rectify that, and I see it starting to become rectified, but it looks like the cart is in front of the horse a little too far. I'm trying to catch up to it. I can't quite reach it, but it looks like I can reach it now, but it looks like I'm out of time.